welcome to In Depth. I'm Teena Jha. To defend democracy, we need not only independent judges and noisy journalists, but even independent journalists and sometimes noisy judges. These are the words of Justice Ranjan Gogoi, the man who will be the 46th Chief Justice of India. As the most senior judge in the Supreme Court, Justice Gogoi's name was recommended by Chief Justice Dipak Misra, who retires on the 2nd of October. Justice Gogoi will be the first Chief Justice of India from the Northeast, where he started legal practice as a lawyer 40 years ago. Over the years, he earned a reputation for bluntly speaking his mind, often described by his colleagues as independent, intelligent and courageous. Today in Depth, let's know more about the CJI designate, about his journey in Indian judiciary and some of the most important judgments given by him. On 4th September 2018, Chief Justice of India Dipak Misra sent a letter to the central government recommending Justice Ranjan Gogoi as his successor. This as per convention of passing on the baton to the senior-most judge. Justice Gogoi will be sworn in as the next CJI on the 3rd of October, a day after his predecessor demits office. In this report, let's take a look at Justice Gogoi's journey in the Indian judiciary and his early life. Justice Ranjan Gogoi is set to take oath as the 46th Chief Justice of India on the 3rd of October. He will become the first person from Assam and the Northeast region to hold the highest position in Indian judiciary. Justice Gogoi was born on the 18th of November 1954 at Dibrugarh in Assam. He is the son of former Assam Chief Minister Keshav Chandra Gogoi. Justice Gogoi did his early schooling at Don Bosco in Dibrugarh and his pre-university from Cotton College, Guwahati. He graduated from the prestigious St. Stephen's College, Delhi University with honours in history. He also completed his post-graduation and law from the Delhi University. In 1978, Justice Gogoi was enrolled at the bar, followed by practice in the Guwahati High Court. In 2001, he was appointed as a permanent judge to the Guwahati High Court. After serving for nearly 9 years in the Guwahati High Court, Justice Gogoi was appointed as the Chief Justice of the Punjab and Haryana High Court in 2010. On 23rd April 2012, he was elevated to the Supreme Court. During his tenure at the Apex Court, Justice Gogoi has given several important judgments. He was part of the Supreme Court bench that ruled that no one would contest elections without making a full and honest disclosure about his or her assets, educational and criminal antecedents. He was also part of a bench that declined to attribute backward status to the Jat community. In May 2015, the Supreme Court held that government advertisements could only include photographs of the Prime Minister, President and Chief Justice of India. This was meant to be a measure to ensure that politicians in power could not use taxpayers' money to gain political advantages. A review petition was filed against this, which was heard by a bench headed by Justice Gogoi. In 2016, Justice Gogoi created quite a flutter when he issued contempt notice against a retired judge of the court, Justice Markande Karju. Justice Karju had, in a Facebook post, criticized the top court's verdict in the Soumya rape and murder case that held the accused guilty of rape but not murder. The judgment was authored by a bench headed by Justice Gogoi. Justice Karju appeared in the court of Justice Gogoi and apologized for the Facebook post, thereby ending the matter. Justice Gogoi was part of the 7-judge bench which held Justice Karnan of the Calcutta High Court guilty of contempt of court. Justice Karnan had alleged corruption in the highest level of judiciary as well as caste discrimination against him, even going so far as to hold the 7 judges hearing his contempt case guilty of offences. In 2016, the Uttar Pradesh government amended the law to allow former chief ministers of the state to continue to retain possession of their official accommodation. This was challenged in the Supreme Court, where in a May 2018 judgment, Justice Gogoi struck down the amendment, holding that this law would create a separate class for such retired public servants, which is not permissible under the Constitution. In October 2017, Justice Gogoi introduced an objective points-based system to decide which lawyers would be designated as senior advocates, which till now had been an opaque process that favoured status over merit. Currently, Justice Gogoi has been hearing the contentious National Register of Citizens case in Assam. It was by the orders of Justice Gogoi that NRC for Assam is being prepared. He, along with Justice Rohit Nariman, are believed to be instrumental in the preparation of the NRC in Assam. As CGI, Justice Ranjan Gogoi will have a tenure of 1 year and 44 days. He will retire on 17th November 2019. Bureau Report, Rajya Sabha TV.
The right to appoint judges of the High Court and the Supreme Court lies with a committee of judges called the collegium. The Chief Justice of the Supreme Court is the head of the committee and 4 other senior-most Supreme Court judges are its members. This collegium has been in force in our country for over 2 decades.
Under the Constitution, the President has the right to appoint judges in the Supreme Court and High Courts. But the Constitution does not have a separate provision for the appointment of the Chief Justice of India. From 1951 to 1973, the Supreme Court's senior-most judge has always been appointed as the Chief Justice of India. According to the Constitution, the President, under the advice of ministers, can also consult judges of the Supreme Court and the High Courts. Let's go back in history to understand the appointment of judges better. In 1973, when Justice A.N. Ray was appointed Chief Justice of India, his appointment superseded 3 other senior judges of the Supreme Court, Shankar Manilal Shelat, A.N. Grover and K.S. Hegde. This triggered widespread protests by bar associations and legal groups across India. It was believed that the other senior judges were not considered for appointment as their judgment in the Keshavananda case was not in favour of the government. Not only this instance, in 1977, Justice H.R. Khanna was replaced by Justice M.U. Beg as the Chief Justice of India. In protest, Justice Khanna also tendered his resignation.
This collegium was created by the Supreme Court in a judge-made law. In sometime 93 or 92, there was a case where the earlier practice, which was consisting for the appointment of the new judges by the government, was amended. And now new collegium system was introduced.
Legislators and judges who criticized the government's move felt that the judiciary's discretionary powers were reduced. This led to the establishment of the Supreme Court's collegium system that appoints judges to the nation's constitutional courts. The genesis of the collegium system is in 3 of Supreme Court judgments that are collectively known as the 3 judges' cases. The first judge's case is the S.P. Gupta case in 1981. In this case, Supreme Court's consultation was taken only as consideration in the appointment of judges. In 1993, a bench of 9 Supreme Court judges led by Justice J.S. Verma reversed this arrangement and considered complying with the Supreme Court's advice to be binding. The court said the collegium will do the transfer and appointment of judges. This decision came to be known as the second judge's case. The introduction of the collegium system actually started with this case. In 1998, then President K.R. Narayanan sought the opinion of the Supreme Court on the meaning of the word consultation under Article 124, 217 and 222 of the Constitution. A few days later, a 9-member bench of the Supreme Court, headed by Justice S.P. Bharuch, ordered on October 28, 1998, that in the matter of appointment, the governor is above the legislature. The Supreme Court's verdict in 1993 was thereby right to say that the consultation was binding. This order of 1998 is known as the third judge's case.
Collegium system is the first 3 judges in the High Court, and they are constituting a collegium, or you can say a committee, and that is known as a collegium, who recommends the name for the appointment of the new judges. In Supreme Court, regarding the High Court judges, only 3 judges are there, senior most, including the Chief Justice of India. About the appointment and transfer of the Chief Justices of the High Courts, there are the 5 judges senior.
Under the collegium system, a committee of senior judges headed by the Chief Justice of India decides on the appointment of judges. The collegium comprises the Chief Justice of India and 4 senior-most judges of the Supreme Court. Other than appointment of judges of the Supreme Court and High Courts, the collegium also decides on the transfers of judges. The collegium also takes decisions on promoting High Court judges to the Supreme Court. Besides this, the Supreme Court has also laid down 9 guidelines for the functioning of the collegium system. Bureau Report, Rajya Sabha TV.
Article 124 of the Indian Constitution deals with the appointment of Supreme Court judges. We've already told you how the President makes the appointment after consultations with judges of the High Courts and the Supreme Court. The Chief Justice of India is to be consulted in all these appointments except his or her own. The 3 judges case that we just told you about is what ushered in the collegium system. The Supreme Court has laid down 9 guidelines for the functioning of the collegium system. Let's now take a look at these guidelines in detail.
The Supreme Court came out with some guidelines and clarifications to improve the collegium system of appointment of judges in the higher judiciary to make it more transparent and accountable. These include the term consultation with the Chief Justice of India in Articles 124(2), 217(1) and 222(1 requires consultation with a plurality of judges in the formation of the opinion of the CJI. The sole individual opinion of the CJI does not constitute consultation. The CJI can only make a recommendation to appoint a judge of the Supreme Court and to transfer a Chief Justice or other judge of a High Court in consultation with the 4 senior-most judges of the Supreme Court. As far as the High Courts are concerned, the recommendation must be made in consultation with the 2 senior-most judges of the Supreme Court. Strong, cogent reasons do not have to be recorded as justification for a departure from the order of seniority in respect of each senior judge who has been passed over. What has to be recorded is the positive reason for the recommendation. The views of the judges consulted should be in writing and should be conveyed to the Government of India by the CJI along with his views to the extent set out in the body of this opinion. The CJI is obliged to comply with the norms and the requirement of the consultation process in making his recommendations. Recommendations by the CJI without such compliance are not binding upon the government. The transfer of High Court judges is judicially reviewable only if the CJI took the decision without consulting the other 4 judges in the Supreme Court collegium, or if the views of the Chief Justices of both High Courts involved in the transfer are not obtained. The CJI is not entitled to act solely in his individual capacity without consultation with other judges of the Supreme Court in respect of materials and information conveyed by the government for non-appointment of a judge recommended for appointment. The CJI can consult any of his colleagues on the appointment of a High Court judge to the Supreme Court or transfer of a judge. The consultation need not be limited to colleagues who have occupied the office of a judge or Chief Justice of that particular High Court. Bureau Report, Rajya Sabha TV.
Under the Indian Constitution, the post of the Chief Justice is supreme. This can be understood by the fact that the Chief Justice of India discharges the role of the President if the office of President and Vice President suddenly becomes vacant in emergency situations. Let's take a look at the qualifications mentioned in the Constitution for such an important post and what are the powers that the Chief Justice of India enjoys.
The Indian Constitution gives the power of appointing judges to the President. The President can take advice on these appointments from the Union Cabinet. For the appointment of the Chief Justice of India, the President can take advice from the judges of the Supreme Court and High Courts and other people as he deems fit. In 1993, a 9-judge Supreme Court bench ruled that a judge's seniority must be considered for appointment of the CJI and that the Chief Justice of India must be consulted for the appointment of other judges of the Supreme Court.
See, as far as Chief Justice is concerned, Justice Misra is going to retire on 2nd of October, I believe. Now, if he, a month prior to his retiring, he is required to suggest, he can suggest his successor, whoever he considers appropriate. He can suggest. Ordinarily, the senior most is recommended, but he can differ. In this case, I think he has already recommended the name of Justice Gogoi, and then it will go to the government, and the President will then either agree with the Justice Misra or may not agree. So it's open to them in that way.
The Constitution, however, does not specify any directives for the appointment of the Chief Justice of India. The eligibility criteria for the CJI is same as that of any Supreme Court judge. Article 124(3) of the Constitution prescribes that for appointment as a judge of the Supreme Court, a person must be a citizen of India, the person must have served as a judge of any high court for at least 5 years, or been an advocate in a high court for 10 years, or is, in the opinion of the President, a distinguished jurist. There is no minimum age for appointment as a Supreme Court judge. A judge of the Supreme Court, once appointed, holds office until he completes the age of 65. Article 124(4) prescribes the conditions in which the post of CJI may fall vacant. These are retirement on completion of 65 years of age, resignation, and removal through proper procedures. The grounds for removal of the CJI are proven misbehavior and incapacity. The Constitution has also underlined measures to protect the independence of Supreme Court judges, including the CJI. That is why the process of removal of the Chief Justice is a complex one. The wages, allowances, leave and pension of the judges is determined by the Parliament and cannot be altered unless there is a financial emergency. The additional expenditure or perks of the judges is borne by the state, but the CJI and judges are not allowed to continue practice in the courts after retirement. Being the head of the Judiciary of India and Supreme Court, the CJI heads their administrative functions and has several special powers. As head of the Supreme Court, the Chief Justice is responsible for allocating cases and appointment of constitutional benches that deal with important matters, due to which he is often referred as the master of roster. The Chief Justice also allocates all work to the other judges, who are bound to refer the matter back to him or her in any case where they require it to be looked into by a larger bench of more judges.
Chief Justice of India is the head of the judiciary, look for the entire nation, and all the courts are under him, and he is first among all the equals. On judicial side, he is equal to others, but on administrative side, he is the head. He can constitute the bench, he can transfer, he can recommend. For example, the next Chief Justice is recommended by him, not by other judges.
On the administrative side, the Chief Justice maintains the roster and has the power to appoint court officials. The Chief Justice also has the power to assist the President in appointing Supreme Court and High Court judges. The CJI also holds the advisory powers in which he or she can instruct and advise the government to work about certain issues. Bureau Report, Rajya Sabha TV.
The Constitution has given an arrangement under which the judicial system for union and states is not separate. In fact, it is uniform for the entire country. The Supreme Court is the highest and final court for appeals in this entire system, under which there are high courts of states and under them are other subordinate courts. This is how all the courts of India are linked, with the Supreme Court being the highest among them. The Supreme Court comprises of the Chief Justice and 30 other judges appointed by the President of India.
The Supreme Court of India is the guardian of the Constitution. It is laid down in Chapter 4 under Part 5 of the Constitution. Articles 124 to 147 state the Constitution and the jurisdiction of the Supreme Court in detail. Articles 124 to 147 in Part 5 of the Constitution deal with the organization, independence, jurisdiction, powers and its procedures. The Supreme Court is the highest judicial forum and the final court of appeal under the Constitution of India. Article 124 provides the provision for the judiciary in India. Initially, the Constitution provided for a Supreme Court with a Chief Justice and 7 judges. At the same time, it gave powers to Parliament to increase the number of judges from time to time, which is why Parliament enacted the Supreme Court Number of Judges Act 1956 to increase the strength of the Supreme Court. In the same year, the number of judges was increased from 7 to 10. As the work of the court increased, the Parliament increased the number of judges to 13 in 1960, 17 in 1977, 26 in 1986 and 31 in 2008, which is its current strength.
Judges' numbers are already fixed, but by looking the workload, the government can increase the number of judges on the recommendation of the Supreme Court Chief Justice. For example, earlier there were only 80 judges in Allahabad High Court. Now they have recommended additional judges, which is going to be 160. Though they never appointed 160 judges at one time. So that is there. In Supreme Court also, originally there were 24, now there is 31, including the Chief Justice of India. So it depends on the recommendation of the Chief Justice, who look for the workload and can recommend to the government, and government can create the additional posts.
The Supreme Court was established on the 26th of January 1950, while it came into being in its present form on 28th January 1950. Its inaugural session was held at the Chamber of Princes in Parliament House complex. It was here that the Supreme Court sat for 12 years between 1937 and 1950. In 1958, the Supreme Court moved to its present premises. Every Supreme Court judge is appointed by the President of India. The Constitution provides a unified judicial system, keeping the Supreme Court at its apex. Therefore, the Supreme Court exercises enormous powers and functions. India's Supreme Court has more power in comparison to the Supreme Court of any other country, given its nature and extent. It has extensive powers in the form of original, appellate, and advisory jurisdictions. The Supreme Court controls the entire judicial system in India and occupies a very significant place as the guardian of the Constitution and custodian of the fundamental rights of the citizens. The responsibility of interpreting the Constitution rests with the Supreme Court of India. The question of law decided by the Supreme Court is binding on all other courts within the territory of India. Article 129 of the Indian Constitution deals with contempt of court. Article 131 provides that the Supreme Court shall, to the exclusion of any other court, have original jurisdiction in any dispute. It has the power to settle disputes between the government and the states or between states. As the final court of appeal of the country, it takes up appeals primarily against verdicts of the high courts of various states of the Union and other courts and tribunals. Article 137 has empowered the Supreme Court to review its own orders or judgments given earlier. The Supreme Court also enjoys the power to withdraw cases pending before a high court or more than one high court for disposal by itself.
Court of appeal, because every judgment, everyone has a right to appeal. Every accused person, every defendant has a right to appeal. So higher court is known as the court of appeal. For example, the magistrate is there, then additional district judge is there, high court is there, high court, but Supreme Court is the final court. In Supreme Court, everything attains the finality.
Apart from this, the Supreme Court's advisory jurisdiction has been discussed in Article 143 of the Constitution. Under this, the President may approach the Supreme Court for advice on questions of law or fact of public importance which may have arisen or are likely to arise. The Supreme Court may, after due inquiry, report to the President its opinion on such matters. Bureau Report, Rajya Sabha TV.
And that's it from us in today's edition of In Depth. We'll be back same time tomorrow with a focus on another subject. You can also watch our episodes online on YouTube and Twitter and get back to us with your feedback and suggestions. Thanks for your valuable time.